Who gets the possessions if someone passes on without an estate plan? Attorney Stephen Bliss says every state has a law of intestate succession. Someone who left a will would exercise their testamentary capability, which would basically be like deciding where their possessions would go when they died. So if they had not done that, then the state law of intestate succession would dedicate where their things went. In California, if somebody was married, then everything would go to their spouse. If it was community property would be everything the person had acquired during that person's marriage. Separate property would be property that the person had before the marriage. So in that case, some would go to the person's spouse and some would go to their kids. If the person was not married, then their property would go to their children. And if there were no children around, then it would go to the person's parents. If there were no parents living, then it would go to the person's brothers and sisters. And on until an heir could be found. The person might not want their property to go to a certain person, but if they did not make any advanced decisions regarding where they wanted their things to go, then the state would have to decide for them. For a free consultation, call attorney Stephen Bliss at 858-278-2800 or visit his website at www.steveblisslaw.com.